And thank you, go ahead. It's come to the people's attention that the day after arraignment, the defendant did make one singular call to the victim in this case. I have listened to that call with defense counsel. During that call, the defendant does ask the victim if she is going to come to court a couple of times. He also it was a arraignment, someone or provide them to someone in some shared form. This time, it's on that bond, but I should the court decide to revoke the defendant's bond, also it's following the text. Thank you.
Good. Thank you, Your Honor. Your Honor, the call was short, as indicated, was only one call from the Washington County Jail. The plaintiff, Mr. Washington's wife, there was his bond included a condition that he could be released on tether. At the time of the arrest, all of his belongings were left there in the care of his wife. It's also my understanding, at least from listening to Paul, I did have an opportunity, that he did have other people attempt to contact her for this to obtain his cell phone so that he could be released on tether. Unfortunately, she was not taking those calls. Mr. Washington contacted her directly himself to ask for the phone to be provided to his father. In the course of what's appeared to be marital frustration over issues that were not related to the allegations in the police report, the conversation began to go south a bit. And at some point, as it's more of the back and forth in this southern part of the conversation, as opposed to the initial eastern part of the conversation where they were talking about the phone, Mr. Washington did ask in some level of frustration, well, are you coming to court? And that he knows is inappropriate. Is that right? Yeah. And he also knows now he is very clear that he should not have made that phone call, even though she was not responding to other persons that he had attempting to call her, such as his father and another friend of his. It is my understanding that once he obtained the phone and Community Corrections met with him and went over all the orders with him, again, very clearly, that he is very, very clear that what no contact means, and he has not had any contact. He also has not had any violations of the tether, is my understanding. Yeah. And he has been just trying to make sure he appears in court and does the other things that he is ordered to do. We're asking that, Your Honor, please give him a stern warning. He is very much aware that this was a poor choice, and we've talked about this in probably more detail than he would like. And so we are asking, again, that the court give him a stern warning that this will not happen again. And it has not happened since. Is that right?
Well, except that we don't know that, right? Because he's out. I don't know what he's done.
Well, I have.
And what?
I was going to say I have obtained a job since I've been out as well to just pay.
Magistrate told you not to contact. They also tell you that there's another procedure that if you had to get your property, which is called a civil standby, you got to use that procedure. That's how you do that.
I didn't know nothing about it, Your Honor. First,
you have an attorney. You could have asked them. You knew the magistrate said no contact. And then upon the contact, you're talking about the case. Can't tolerate it, and I won't tolerate it. So at this point, I will adjourn this matter out to September 1st. That's a Tuesday, 9 a.m. for a probable cause conference. Defendant's bond at this time is revoked. Defendant's remanded.
Thank you, Ron.
Thank you.
Thank you, Ron.